Hi, Garrett. How are you?
I'm good, Paul. How are you doing?
We should introduce ourselves. I'm Paul Trudelle,
And I'm Garrett Horrocks.
and we are podcasting virtually just to keep things going. And I hope that everyone out there listening or watching is doing well and keeping safe. We're keeping our social distance here and trying to do our best to stay safe as well. We're podcasting today on a recent decision of the Ontario Superior Court of Justice, the estate of Henry Calmusky, Calmusky. And we'll put the link to that case up on our bio. But it's an interesting case that deals with joint accounts and beyond.
Yeah, so I'll start with a brief rundown of the facts here. In a way, it's for our listeners who are familiar with the podcast and who are longtime listeners in a sense. This is kind of your quintessential Pecore versus Pecore and Pecore scenario, I should say. In this case, there was a testator who had two surviving sons. His wife passed away back in, I believe it was 2014, and shortly thereafter, one of the sons took the father to the bank, and they had a discussion with one of the financial advisors, and the son was placed on title to certain joint accounts or certain accounts that had previously been joint with the father and the wife, but now that the father had held in his solely because the wife had passed away. And in a way, that's kind of the quintessential Pecore scenario where an adult child is added on title to a bank account, generally to assist with the payment of day-to-day expenses, because oftentimes it's easier for an adult child to manage that on behalf of a parent. And again, for those of you who are familiar with the Pecore decision, the court imposes a presumption of resulting trust where an adult child is added on title to an asset, in this case, a joint account, where the adult child doesn't make any contribution to that account. It's presumed that if the parent dies before the adult child, that child does not receive the proceeds of the account by right of survivorship, as would typically be the case for a joint account. Rather, the proceeds are deemed to be held on a resulting trust, or there's a presumption of resulting trust in favor of the estate. So it's a rebuttable presumption that allows the surviving title holder to lead evidence to show that the deceased title holder intended to give the proceeds of that account to the surviving title holder. And there's the court decision gets into a number of strings of evidence that can be relied on. I don't think it's necessary to explore those here, but suffice to say that is essentially kind of where this case landed. In that, again, the surviving or the parent died, the adult child claimed that the proceeds of the account were gifted to him. His twin brother disagreed, and hence litigation is commenced.
So this was like a straight application of that. The presumption applied unless it was rebutted by the joint account holder. The court looked at the evidence of the joint account holder and whether it rebutted the presumption or not. There was some evidence that might work towards rebutting the presumption, but there wasn't enough in this case. The presumption applied and the joint accounts were bound to be held in trust for the benefit of the estate. The case goes a bit further, though. There was about $280,000 in the joint accounts. There was also a RIF with $40,000. And there was an argument by the son who was the joint account holder, who was also the beneficiary under the RIF, that Pecore doesn't apply to RIF. It's not a joint right of survivorship type scenario. It's a beneficiary designation, and Pecore shouldn't necessarily apply. And the judge didn't accept that argument. The judge felt that, or found that the reasoning with respect to joint accounts and presumptions that apply should apply equally to RIFs. There was some case law from outside of Ontario to that effect that applied them to RIFs, and that was found not to be binding, but was persuasive and applied to the case in Ontario before the bar with respect to RIFs. So this case may be seen as a bit of an extension of Pecore to beyond just straight joint accounts to RIFs, and is going to be useful or not useful depending on what side of the case you're on.
Yeah, I mean, it's not a case, or it's not, a scenario that we see very often. I mean, typically RIFs are seen to be somewhat unassailable in terms of, or at least maybe that's how they're viewed certainly by estate planning lawyers and financial advisors. They're seen as somewhat unassailable in terms of the effectiveness of the beneficiary designation. And that's supported in part by looking at certain provisions of the Succession Law Reform Act, Section 51 and 53 give effect to that, and also with respect to certain other designated assets, such as life insurance. You can look at the Income Tax Act or the Insurance Act. Designated assets in general are seen as, I don't want to say there was a presumption that they'd pass outside the estate, but there was that was kind of the general approach to estate planning techniques with respect to designated assets, is they were essentially treated as inviolable.
Yeah, in this case, I think calls that into question and says the reasoning that applies to a joint account, the presumption of trust, should apply equally to a RIF. And I think there may be, a basis for that, and we can debate whether it should be or shouldn't be. But I think that when dealing with RIFs, as with joint accounts, I think it's incumbent or imperative that the recipient has that evidence in order to satisfy a court that there was an intention to make a gift. And I think as testators or people making the will or doing estate planning must ensure that this sort of application of the presumption is rebutted if that's their intention, by making it clear what their intention is. Is it meant to be a gift, or is it meant to be held in trust for the estate? And I think that lawyers who are doing estate planning should turn their minds to that as well, so that evidence is available. In the Calmusky case that was before the court, the deceased went and revised his will at the time he set up the joint accounts and the RIFs. There was no evidence, though, available from the lawyer as to any discussions with respect to, well, what was your intention with respect to the joint accounts or the RIFs? And that would have been helpful, I think, to avoid this problem if it was available and if those questions were asked.
Right, exactly. And one of the salient points that came out of Pecore dealt with the nature of certain evidence that can be led to rebut that presumption. And in this case, certainly bank documents are one of the kind of prevailing forms of evidence that are typically used. And the court in Pecore and in the Calmusky case were both been critical about how that evidence is not necessarily indicative of who holds beneficial title to that asset. Rather, it's just a statement of who holds legal title. So really, if a child and a parent go to a bank and open a joint account and you're looking at potentially bare bones account opening agreements, the court's not going to be satisfied with, that's not going to be, I guess, sufficient to rebut the presumption of resulting trust. And the court's not going to be satisfied with that alone. The court's going to expect a little bit more of an intention or a gift intention. So whether that's done in the form of maybe there's a reference in the will, or maybe banks start incorporating more fulsome account opening agreements potentially, or beneficiary designations.
It's surprising we're not seeing different documentation from banks where they ask, okay, is this a joint account with right of survivorship? Yes. Do you really mean that? Do you want the person to keep it as a gift, or do they hold it for the estate? Yes, no. And then we can deal with that and avoid a lot of litigation, but we're not there yet. And maybe the banks don't want to get into that discussion. But it is something that, it seems like it's a problem that could be easily avoided if the person making the gift or setting up the joint accounts turns their mind to it.
No, exactly. It'll be interesting to see what the fallout, so to speak, from this case will be. I mean, certainly it'll cause estate planning lawyers and financial advisors kind of turn their mind to what different steps should be taken in the meantime.
Right.
Maybe a higher court will have to say about the decision, and it'll be interesting to see what develops in the next months.
Yeah.
But for now, I mean, there's certainly some additional steps that should be taken by those professionals, in order to support any gift intention, for example.
That's right. We, to the extent we can, if we can avoid litigation, then we could organize affairs to do that. And if not, then we'll litigate over this.
That is a benefit to everybody.
Yes. The decision also has an interesting discussion on occupation rent and when it should be payable, and whether it should be payable in this case, where the one son was living with the deceased up to the time of his deceased's death and continued to live in the house after that. And the question was whether he should be paying occupation rent. And the court went through an analysis of the unjust enrichment. There was a juridical reason for that, and we won't get into that now, but that's an interesting matter to discuss. And it also addressed other estate expenses relating to cars and the occupation of the house, and who should be paying for those. So all in all, it's a great discussion of Pecore and an extension of it, the application of Pecore perhaps, and other issues of occupation rent and expenses. I think that will take us to the end of this podcast now. We'll wrap it up. Thanks very much, Garrett.
Thanks very much, Paul, and we hope everyone stays safe and continues to stay safe.
Yes, and if there's any questions, please send us an email. Our address is on our website. And yeah, stay safe.